Well, good morning, everyone. Thanks for coming to our December Community Coffee Hour. I'm Tamise Spencer-Helms, pronouns are she, they. I am the Training and DEI Manager here at Mentor Virginia, and we're really excited to have Shariful Khan here today to talk to us about protecting children from racism in schools. So talk a little bit about who we are, and if you want to go ahead in the chat, put your name, your pronouns, the program that you're with, and your role. And go ahead and throw that in the chat there. And just a really quick reminder about Mentor Virginia. Our Mentor Virginia's mission is to foster quality mentoring relationships that empower, elevate, and encourage young people. Some of our services are training, AmeriCorps Vista, no-cost consulting, our TA, Technical Assistance Program, and then our NQMS National Quality Mentoring System. Here is a look at our team. We have Patrick Sezik, Pamela Johnson, we just brought on as a Youth Impact Coordinator, Cindy Montalvo, Virginia Patterson, Emma Rush, myself, and Sarah Wilkinson. So we welcome you all today, and we're looking forward to a great community hour. Here is a list of all of our consultants here. I'm not going to name them all for time's sake, but you can see them all here. And today's topic is protecting children from racism in schools. And so, Shariful, without further ado, I'll go ahead and toss it over to you.
Thank you, Tamise. Thank you, Sarah, and thank you, Tamise, for helping organize this event. I see Amanda's in the waiting room. Okay, great. My name is Shariful. I'm excited to be here today. I'm an attorney in public justice, and I work with the Student Civil Rights team on litigating racial harassment and sexual harassment, racial discrimination, sexual assault in schools. Today, we're going to talk a little bit about racial harassment, discriminatory discipline, and retaliation in schools. I have a little slide for us that I'll pop up in a second, but I just wanted to say that I will leave time at the end for questions, but you should feel free to raise your hand or message anything in the chat at any point, and I'm sure someone will let me know that there's a question in there. And I will also leave my email at the end of the presentation for you to contact me, or leave inflammatory reviews or anything that you want to do with that email. So I will throw the presentation up. Okay, looks good. Great, thank you. Okay, so racial harassment, discriminatory discipline, and retaliation. A little bit of an overview, your role, and what you can do about it. So a quick about me, I'm a fellow in public justice. I work with the Student Civil Rights team, like I mentioned before. Although we are based in DC, we work on cases nationwide. For those of you unfamiliar with public justice, which I imagine is most of you, we're a nonprofit legal organization that's been around for 40 years. We take on some of the biggest threats to justice. So that means not just student civil rights and civil rights generally, but also abuse of corporate power and the destruction of the Earth's sustainability. We do so by connecting high impact lawsuits with strategic communications and the strength of our partnerships to fight abusive and discriminatory systems and win social and economic justice. A bit of a word vomit, but we do good work. I like to think we do good work by bringing effective lawsuits that we think can bring change, not just in that one case, but in many cases and on the law as a whole. And we do so by working with organizations like Mentor VA and other organizations around the country to figure out what the biggest issues are and work with the local organizations to attack them. SCRP, Student Civil Rights Project, is one of VJ's programs. SCRP combats harassment and other forms of discrimination in schools so that all students can learn and thrive. We focus primarily on cases and issues involving discrimination on the basis of race and sex, including sexual orientation, gender identity, and gender expression. And the overarching goal of SCRP's work, both its litigation and advocacy, is to effect broad systemic change. So we accomplish this in several ways. First, like I mentioned, by bringing effective lawsuits to make it easier over time for victims to hold schools accountable for their wrongdoing. Two, reaching settlements with schools that not only compensate victims for the harm done, but also include relief requiring schools to improve policies, procedures, training, and education. And three, doing education outreach, like what we're doing right now, know your rights programs for students and their families, education programs for attorneys representing student victims, and networking with partners who continue to press for change beyond a particular case. That's a little bit about me. Today, I'm here to talk about the legal protection against race discrimination in schools. I should say up front that I'll be sharing general information that I hope will be useful to you all. And I know Sarah mentioned that many of you work with mentors, so hopefully to the mentors that you work with, but I won't be able to give legal advice about any particular situation. And if you're interested in pursuing legal action yourself, feel free to reach out to me afterward. We'll also talk about the unique role parents or mentors can play, because I think that's a really great part of Mentor VA's ethos and organization. And I think it's a unique part of my presentations that I don't normally have. So I'm going to start up here. This is like where it gets a little boring in school, but hopefully I can make it somewhat interesting. Students have a right to an education free from discrimination based on race, color, or national origin. That's point blank, that's straight up. There are two national laws that actually impact this right. So Title VI of the Civil Rights Act of 1964 and the Equal Protection Clause. Both apply to public schools, but only Title VI applies to some private schools too. And the way you determine which private schools are actually impacted is based on which schools actually receive federal funding. I assume a lot of you know what that means, but just to clarify, federal funding means when the federal government is actually giving money to a school to help run its programs, and some private schools accept money in order to make that happen. It's not really a discrete sort of funding. So that means it's not like if a private school only receives federal funding for school lunch, that they then can't be sued, then their basketball team can't be sued later on for a Title IX violation. It's if you accept money in some part of your school, you are a recipient of federal funding. If you are a recipient of federal funding, you have Title VI, which applies to you. Some states and cities also have additional protections. I won't be getting too much into that because it varies a lot based on where you are and what you're doing. But I just wanted you all to be aware that states and cities sometimes have additional protections. So there are many different kinds of race discrimination. I'm going to talk about 3 today, but I would just caution that that's not all forms, but they are some of the more common ones today. We have racial harassment, discriminatory discipline, and retaliation. Starting with racial harassment. Racial harassment is bullying based on race. It can be verbal or physical, take place online or in person. It can be committed not just by other students, but also by teachers and even by visitors to a school. The main takeaway here is that schools have an obligation to respond to harassment. They're required to take steps that are reasonably calculated to end the harassment. That means that it's not just any step, it's a step that actually reasonably calculated to end the harassment. So when schools don't meet this requirement, they are breaking the law. An example of what I'm talking about is a lawsuit we brought in Duluth, Minnesota a couple years back. Public Justice brought the lawsuit against a charter school network where Black students were regularly called the N-word, physically attacked, and harassed in other forms. The school occasionally told the bully to stop, but never took any actual steps needed to make the harassment stop or to provide the victims the support they needed to feel safe in schools. And as a result, the court said they had violated Title VI and the Equal Protection Clause. That's racial harassment. I'll talk a little bit more about everything later on in the presentation, but just a little bit of an overview. Discriminatory discipline. Schools cannot discipline students differently based on race. For example, a school can't discipline a Black student for doing something that white students do all the time without getting in trouble. This applies to both formal and informal discipline. So what that means is formal looks like suspension, expulsions, anything that goes through a formal written process. And informal looks more like, it can look like anything really, but it ranges from missing class time to not being called upon in class to being removed as the captain of the sports team. You cannot discriminate when handing out discipline. And another example from our Duluth case, public justice sued a school where a Black girl was often forced to change for dress code violations that white students did not get in trouble for. This is fairly common. She wasn't formally suspended, but still lost class time when she was removed from the classroom to change. So that's an example of informal discipline. This is not going to be news to any of you who are on this call, but much of discriminatory discipline is driven forward by racial stereotypes. For example, Black boys are often seen by teachers as more violent and may be punished for fighting, for example, when they excuse the same conduct by white students as ordinary playground roughhousing. Similarly, teachers often see Latina girls as more sexually mature than their white peers, and so may discipline Latina girls for, say, wearing a short skirt, even if white girls wear the same thing all the time and are not disciplined. Retaliation. It is unlawful to punish someone for reporting or complaining about harassment or other forms of discrimination. For example, a student cannot be suspended because they report they are being harassed based on their race. Again, the main takeaway here is that students are not the only ones protected from retaliation. If for example, a parent reports that a student was being discriminated against, and the school then goes ahead and removes the parent from every single PTA committee that they were on, that is still an example of retaliation, and the parent can bring a retaliation lawsuit, even if they themselves were not the object of the harassment or discrimination. That goes for not just parents, but also, say, teachers, say, mentors who are involved in the school in some way. People who are retaliated against can bring a claim of retaliation. Now, I think this is the more meaty part of the presentation for a lot of you that work with parents or mentors right now. I think a couple of big things that parents or mentors can do that they are uniquely positioned to do that lawyers can't is identify discrimination, support student, and identify students' options. So real quick, let's run through them. If a student is experiencing racial harassment or discrimination, parents or mentors may be well placed to help the student figure out what they want to do. So first, identifying discrimination. A really important role parents or mentors can play is helping students realize that what they are experiencing is not okay. I know this might seem simple, but I also know that many of you probably work with kids who don't necessarily know what discrimination or harassment might actually look like. So a student might not realize that what they are experiencing in school is harassment or discriminatory discipline. In this role, parents and mentors serve as watchdogs for the students and help them make their own decisions. Parents and mentors can also keep an eye out for retaliation a student might not recognize as such. Like I mentioned earlier, retaliation can take many forms. For example, a teacher choosing to not call on a student anymore, being cut from a sports team or receiving less playing time, or being sent home early. At base, I would remind all parents or mentors that they should remember to be supportive and avoid laying blame on the student for being harassed or otherwise discriminated against. Students can sometimes feel guilty or ashamed for being bullied or unjustly punished. And it's important to remember to be kind, supportive, and to help them feel like they have an adult they can turn to and trust. So we'll discuss what you can do in response to harassment and other forms of discrimination in a moment, but it's also important to support students in pursuing the remedies that they want. So part of your role, part of parents and mentors' role can be to help identify, to help students identify their options and then help find out which one is actually right for them. So, for example, sometimes students are really eager to address the problem. Sometimes students are rearing to go. They want to bring a lawsuit. They want something to happen. They're frustrated. They're tired of discrimination and being harassed. Sometimes they don't want to do anything about it. They're tired. They're scared. They want to just ignore it. They don't want to affect their social standing. They might have any number of reasons for not wanting to do anything about the racial harassment or discrimination they're going through. As a general matter, we encourage adults to follow the lead of student victims. Let them choose what they want to do. There may be times, of course, when you strongly believe an intervention is necessary, but a student does not want to take any action. That's hard. It's a difficult position to be in. In this respect, I think a lot of you would agree, and it's true that parents and mentors may be differently positioned to decide whether to act against the wishes of a student. The age of a student may also inform what decision makes sense to pursue. Of course, be aware that there are situations where mentors may need to act as a mandatory reporter. If you are a mandatory reporter in Virginia because of your day job, like a teacher, doctor, or domestic violence worker, then you may need to report physical and sexual violence against children, but otherwise make judgment calls and commit to helping students pursue the remedy that feels right. And now, working to identify students' options. Once a student has identified discrimination, harassment, and has decided they want to do something about it, there are a couple things that they can do. So first and foremost, the option that we usually recommend going with first is working with the student, working with the school. So some things that you might recommend to a student or keep in mind if you're filing a complaint yourself, it's often best to report to an administrator like a vice principal or someone more senior that there is harassment, discrimination, or retaliation happening. This both is more likely to actually spread the school to change. It's less likely that you can go to a teacher who can then go to the school and say something about change, whereas a principal or a vice principal is more likely to actually be able to implement change. This both is more, so it's also important to protect the student's legal rights if they want to sue down the road. Look to the school's policies. Pointing out that the school is violating its own rules can sometimes be an effective vehicle of change. This is important. We also really suggest that all evidence is preserved throughout the process. So if, for example, a student is being racially harassed, a parent brings the complaint to a school and wants to talk to the principal about how their child is being racially harassed. They've sent emails, they sent follow-ups, they have not been, they've either gotten no email in response or kind of blasé, like we're looking into it, we'll let you know, and then never get followed up with. All of that evidence is really important to keep. So document everything, don't delete text, keep emails from administration, and record instances of harassment to the extent possible. If the school is resistant to efforts to solve the problem, which they often are, that's how my job exists, talk with students about filing a federal complaint to the U.S. Department of Education's Office for Civil Rights. There are pros and cons to the Department of Education's process. The pros are you don't need a lawyer, though it's sometimes helpful to have one. The department investigates for you, so there's less pressure on you as a student. And the department can require the school to implement important policy changes. The cons are the investigation might be really slow. The outcome might unfortunately depend on the policy views of the party in the White House. And parents and mentors and students exert less control over the investigation, which also means that you end up with less options in terms of your remedies. So for example, money is unavailable when you go through the Department of Education. There's also litigation. So hiring a lawyer is a big step and not one everyone is always ready for, but if the harassment or discrimination has gotten to an extent that people feel like they need to get a lawyer, there are options to get a lawyer. So some lawyers work on what's called a contingency fee, which means that the student does not need to pay up front and only has to pay if the student actually receives a monetary award from the suit. So usually there's an agreement made up front that a lawyer will receive 3% of a settlement agreement between the school and the student. There are pros and cons to hiring a lawyer too. Pros include that a court may order the school to pay student victim money if you pursue litigation. Students, parents, victim, and mentors can exercise more control and have more input into litigation than in a federal investigation because your lawyer is yours. You've hired that lawyer and you can tell them what you want to do. But there are cons. So for example, it's sometimes hard to find a lawyer, especially a good lawyer. The lawsuit process may be stressful for students and their families since they need to ask to be questioned by the other side's lawyers and participate in public trial. And even though it is faster, it can still take a while as well. So what lawyers will want to know. If you end up going to a lawyer, or if your parent or mentor that you work with ends up going to a lawyer, they will have questions about the circumstances surrounding the discrimination against the student and what has been done since. It may be useful to know some of these questions beforehand as they can guide the student's actions or responses. So, is the racial harassment or discipline explicitly race-based? What evidence is there that race played a role in the discrimination? Who has the discrimination been reported to? For harassment especially, it's important to make sure that an administrator at the school, like an assistant principal, knows what's going on. How has the school responded to reports thus far? Have they taken reasonable steps to address the harassment or discipline, or have they kind of twiddled their thumbs and done nothing? In cases of discriminatory discipline or retaliation, was the person who disciplined or retaliated high up the food chain in the school? And what was the effect on the student? Did it force them to miss class or extracurriculars, make them avoid coming to school? Did their grades drop? Indicators like these both help strengthen a case and also make it more, make damages more possible at the end of the case. So that's the end of my presentation. I'll leave some time now for people to ask questions. I want to thank you all for being here at 9 a.m. on a Wednesday. I know you probably were eating breakfast, drinking your coffees. I'm at my parents' house, and you can see there's like a little picture of me from the 3rd grade over here. And so this is a big adventure for me too, but I appreciate you all being here. This is our website. This is my email. You should feel free to reach out to me about any questions you have about discrimination, retaliation, racial harassment, or discrimination in general. I'm happy to direct you to the right resources if I don't have the answers myself. And even if you just want to talk about what you can do for parents or mentors to help them know more about their rights, feel free to reach out to me. I'm always happy to provide more presentations, talk to families, do whatever. Thank you, everyone. And I'll leave some time for questions now.
Awesome. Thank you so much. We don't have any questions in the chat, so folks want to come and unmute. If you have follow-up questions, feel free to also write things in the chat if that is more comfortable, and we'll make sure to read those out and get answers for you.
No pressure. I do know it's 9 a.m. And I'm definitely available over email if people want to ask questions later on. Also, Virginia, good to see you again. It's been a year since you helped me write my little letter to get this fellowship.
Good to see you as well, Shariful. I appreciate your presentation, sharing with everyone. Coming out of K-12 education and understanding some of the experiences that Sharif was actually sharing with our team and our colleagues on. It's very important that we become aware, but more importantly, that we are in tune to our young people and what they might be experiencing, to at least be able to connect them to the right people to address any concerns that they may have as it relates to discriminatory practices. And although we may not want to believe that it occurs, it indeed do occur. It happens on almost a daily basis. And when a young person is sharing with you and telling you that they're experiencing some type of discriminatory practices, just take that actual time to lean in and listen, and then figure out how to navigate and manage the situation based on the right resources, the right human resources and individuals to support them, because that support is definitely needed today in this day and time. And we see a lot of racial things happening, unfortunately, to all groups of people. For whatever reason, people are finding that to be in the best interest of anyone. I'm not sure why we're seem to be taking steps back as opposed to moving ahead, and more importantly, really trying to support our young people and be leaders and model for them what is right and really what is in their best interest for the future, because we all are created to be contributors and assets to human society, and everyone should be treated as humans. Sorry for my little
No, that was
spell there.
Careful, I have a
You're
question.
just saying hi to me, and then it's somewhere, I don't know, that came out of.
I have a question. So
Sure.
how long is the typical time frame from the moment a person submits a complaint or reaches out to you all? Have you seen, I mean, what's the typical average time frame from start to finish?
I wish I could give you a straight answer to that, and I'm not going to be able to. And the reason why is because cases really, really vary. So to give an example, if a person brings us a case and it's totally new, like they haven't gone through the trial process yet, they haven't done anything, it's just, hey, my kid has gone through this experience, like what can I do? One school that we might reach out to, so we, like draft up a demand letter, we communicate with the school, we tell them this is happening, we tell them that we're representing X family. One school might immediately say, throw up their hands and say, oh my God, so sorry, let's fix this, let's settle, let's deal with this, let's fix it, move on. Another school, on the other hand, might completely decide to stonewall us and fight us in every single step and want to litigate and have the case go to trial or have the case go in front of a judge, that sort of thing. And so the first case obviously can take, a couple weeks, a couple months, whereas the second one, if the school really wants to slow down the process, can take a year, more than a year, that sort of time frame. And then after that, there's always appeals and other processes. So I would say the timeline can really vary from honestly a couple of weeks to more than a year or 2 years.
Okay, thank you.
And I would submit that anyone who stonewalls, that's naive leadership. They should be addressing that immediately and taking care of the student first.
Absolutely.
I'm curious about, is it more common to have, to see cases being brought with students who are older, kind of like more at the middle or high school range? I mean, do you see, like, what is it? I'm just curious logistically, how does a student that might be really, really young, like second grade, for example, how would they really be able to make an informed decision for themselves about, what it means to take something to trial or something like that? I'd just be curious how you all handle that when the student might be young versus when they're a bit older.
Yeah, that's a great question. And I'll caveat with the fact that I just have not been justice for enough time to really see all the cases we handle. But I will say that I think there are a couple of things here. First, I do think we get cases from families with kids that are a little bit older. And that's not necessarily because kids who are older just experience more discrimination, but also because it's usually easier for a kid who's older to be able to identify it and report it to their parent and express it, what's happening to them in a way that a parent can identify what's going on and wants to bring a claim. So even though kids go through the harassment all the time, discrimination all the time, it's usually a little bit harder to put words on that and really be able to identify as easily as you can with an older student. In terms of questions about, bringing litigation, how does a kid know, or how does a younger child know the implications of bringing a lawsuit versus an older child? That's a really good question too. I will say at that point, it often comes down to what parents are ready to do. Obviously the younger a child is, the less involved they'll be in the actual process of litigation, and the more so a parent will be. And the parent is expected to be more of a reporter about what's going on and be able to identify what's going on. And that can be a lot of pressure for a parent or to be involved in, because they have to start documenting everything. They have to start knowing what's going on, that sort of thing. A lawyer can be helpful here in order to just, take off the pressure a little bit from the parent. But all that being said, I think in litigation or when filing a lawsuit, when going through the lawsuit process, older kids are often more well represented, both because of who is more often able to report and who can actually themselves be a bigger part of the process and take the pressure off the parent. I hope that answers your question.
Yeah, that's very helpful. And it looks like we did get a question in the chat from Pam. And so Pam writes, so during that process of 2 weeks to 1 year, 2 years, how do you keep parties calm, make sure, help them to not give up, etc.?
That's a really great question. And it's a hard one, because I will tell you what we do, and I think it's helpful what we do, and I think it's mostly all we can do. But there's no way to get around the fact that this is a slow process, and it's demeaning to go through. and it's frustrating and angering to have your child or you yourself be going through a really horrific time and really horrific process. And the entire time, it seems like everyone is kind of pushing back against you, doubting you, telling you what you experience isn't real, delaying the process for as long as possible. It can be really frustrating and demeaning to go through that, and it can feel absolutely hopeless. What we think a good lawyer can provide is both emotional support and being a bit of a therapist here and saying that, hey, you are not the first ones to go through this. We are sorry this is happening, but we are here with you every step of the way, and you are not going through this alone. We have to go through that a lot with parents who have had a child experience, commit suicide or harm themselves seriously, where the parent is really, really emotionally devastated, obviously. And to try and get some recovery from the school to make the school say that they did something wrong is often a really difficult process. And the school will certainly drag its heels along, most of the time throughout the entire process. And so being there for the parent is really important in terms of just reminding them that they're not going through this alone. But besides that, and I think this is a really important question just overall, we can also try to lay out the landscape up front. That's why we do presentations like what we're doing right here. We don't want people to come into litigation not knowing what it's going to be like or what they're going to have to go through. If they come to us and say that they want a result in 2 weeks guaranteed or 2 months guaranteed, we're going to say that we can't guarantee that. And if that parent refuses to see it any other way, then we will say that we wish them a luck with their case, but we can't help them because we just have to make sure that they have the expectations of what litigation and lawsuits can look like, and they can often be slow. And as long as we're honest with parents, we have found that most of them are very open to hearing what it actually looks like. Thank you, Priscilla.
So I would be curious too, for your organization, specifically public justice, when you have a lawsuit and you're working with a family and a young person through kind of a process of litigation, do you all bring any other resources to kind of, do you partner with other folks in the community to provide additional resources to those families? Because I can just, it's impossible to put myself in a situation where I'm imagining what that would be like, but it's got to be extremely traumatizing for the family as well as the young person, especially if this is a drawn out process, if they're having to recount, if they're being gaslighted, which it sounds like from what you were saying that's a common kind of piece of potentially going through trial. So what does that look like to bring in other resources to kind of support folks along the path?
Yeah, that's a great question. We will say that I think in informal conversations with parents and families, we certainly suggest those sorts of things. We tell them that litigation is one part of the puzzle, but it doesn't really solve any of the emotional traumas and harms that happen. That being said, one thing that we do find actually does help parents and families emotionally is that because our lawsuits are not usually strictly monetary based, we're also looking for equitable change to push a school to not just hand over money, but also actually change policies, hire a new coordinator, add a new initiative, do something that actually will impact kids long after this one case is over. We have found that actually provides a lot of families with some degree of emotional comfort and support, only to remind them that the trauma that they went through will not be meaningless. We will give meaning to it by creating change in the system and by making sure that other students do not have to go through the same thing, or if they do, that they have even better resources than this family did when going through it. That being said, in terms of your original question about what resources we actually give the parent and the family, we don't normally provide the resources directly, but we do often suggest that there are local services that do that sort of work. A lot of parents that we work with often have strong foundations in their church or in their mosque or whatever, and they often go there to find the kind of community support they're looking for. And we often do recommend people go to therapy after a really traumatic process, because it's helpful to go to therapy for everyone, but we especially think it will be the case for people who have undergone trauma and racial harassment and discrimination, because they often have an outsized view of, or undersized view of themselves, and have underconfidence and a lot of other personality problems that can be rectified through therapy and other resources.
Thank you.
Yeah,
Are there any other questions? Because I could keep asking them, but I also don't want to monopolize the conversation. So if anybody else has things that are being sparked for them, curiosities, please do ask your question.
And of course, my email, I think I left in the chat, but Sarah, feel free to share it after the presentation, and I'm always on the lookout for emails from people like you.
Sharif, could you expand for our audience how a parent may, I guess, decipher between when harassment is happening and discriminatory practices are happening, and one might be teeting over into the other, and what might the reporting process work?
That's a really, really great question. This is actually, funny enough, the basis of my fellowship at Public Justice, which is that racial harassment and discipline often are quite intertwined. So a student who reports harassment then ends up being disciplined, or discipline comes in the form of harassment, and there's things being said during discipline that actually reflect harassment, that sort of thing. So to answer your question, it's not necessarily a cut and dry, this is harassment and this is discipline and this is retaliation, and they're all separate groups that touch each other. In fact, they're often quite interlinked, and that's not necessarily a bad thing. It is obviously quite traumatic and bad for the student, but in terms of legal strategy, it's not necessarily that you have to occupy one role in order to bring a lawsuit. And so when we bring a lawsuit, for example, we will often talk about how all of those things are intertwined and interlinked. And so a parent shouldn't feel obligated to have to identify, what is harassment versus what is discipline, but it is helpful to know what it looks like, which is why I gave a little bit of an overview in the beginning of what discipline can look like versus harassment. But just know that, of course, it can combine, change over, switch together, combine and create a new monster of itself that combined all three elements, but it often actually does look that way rather than looking completely separate. That's a really great question, Virginia.
So I have another question. I'm curious, does Public Justice, do you all track the progress in schools that you litigate over time? There's a set period of time where you're involved with a school potentially in a litigation, but is there any follow-up for you all over a period of time? Like, is there a way, do you all have a mechanism in place to be able to measure whether the litigation brought any like long-term changes to a school?
Yeah, that's a really great question. It depends on the lawsuit that we have brought and the way that litigation played out. One thing we will often do in settlements when we have litigated against school, and now we're trying to figure out what the best remedy is before we're going to trial court, is that we will ask, when settling with the school, and they're saying that they will implement XYZ changes over the next 5 years, and that kind of leaves us in a weird position where we obviously have to accept what they're saying is true, and they are signing legally binding documents that say it will be true, but how do you actually know? We might sometimes ask for progress reports, just like checking in on what's actually happening there, making sure they are not violating the terms of their agreement, because that is actually a breach of contract violation, and something that we can also pursue if they don't agree to, if they don't follow up with what they agreed to do. So in terms of schools that we actually settle with, we often ask for progress reports to keep track of that. But separate from that, we often, when we litigate one student's case against a school and only get monetary damages, a school sometimes still often goes ahead and spurs on its own change in the school without even our input or our additional pressure to bring that change. And the reason why is because when we bring lawsuits, the way I showed in the beginning, we try to attack from a multi-pronged angle. So it's not just bring a lawsuit, file the complaint, and now it's done. What we'll often do is do a combination of litigation and media advocacy. So now there are newspapers in the area saying that, this school and this county has actually had like several instances of harassment over the past several years. And when that happens, then the school feels a lot of pressure to make sure that there's some change happening. That's not just for this one student, but also for students in general.
Thank you, Shariful.
Chef, I have another question, maybe two,
Mhm.
but I'd love to hear about just kind of how you got into this work, what drove you to take this up as what you wanted to do, and then second, how do you all navigate the at-will issue in terms of Virginia? Like, how can you? A lot of times, it would be hard to determine whether or not it was actual discrimination because Virginia is an at-will state.
Mhm.
So have you had to navigate that at all?
Yeah, definitely. I'll take that latter question first. In terms of at will, that's a really big part, of course, about what we do. It's hard to prove discrimination or retaliation when a teacher has been fired, for example, 3 weeks after they noted that one of their kids was being harassed by another kid or by another teacher. So there are a couple of things that I pointed out in my little presentation, but there are other questions that lawyers will ask when bringing in a case to see if there's a chance of, if not directly linking the firing or retaliation or discipline to the report, but also, but if not directly linking, then looking for inferences that will lead to that assumption. So, for example, if if the firing happened 3 weeks after the report of harassment, and the teacher has otherwise been a star teacher and gets glowing performance reviews every single year, and the reason that they were let go was for a pro forma reason, or because the school said that they actually weren't performing up to standards. There are things like that that we can point to draw out the inference between the harassment or the report being the reason that they actually end up being fired. But yes, to me, that's a really good point. That is often one of the bigger challenges of our work, is navigating the hurdles of at-will employment. And of course, schools are often enterprises that are allowed to do what they want, and so you have to navigate the bounds of that. But that's our job, and that's what we do. And in terms of your first question, which is what brought me to this work in the first place, there are a lot of reasons. I've written many a personal statement to get to this point, and so I've had to answer that question for myself a couple times. I would say that the most direct answer that I can give you is I'm a product of public schools, of New York City public schools, and I grew up, feeling very safe in my schools. I grew up in schools of immigrants and low-income people and people of color, and I remember that being a really important part of my education and a part of the way that I grew up. And over time, growing up in the low-income community that I did, I found it more and more important to invest myself fully in my education. And it wasn't really until college that I realized how lucky I was to be able to do that. Because not every kid gets a chance to do that. Not every student gets to go through all of elementary school, middle school, and high school and college and not experience racial harassment or discriminatory discipline or sexual harassment or sexual assault. And that can really transform a school, which is meant to be a place of learning and safety, into a place of real danger and fear, and really discourage students who are otherwise passionate about their learning and passionate about the things they do, and discourage them from going to school, discourage them from learning, make their grades drop, do a ton of different things, and really affect the path that a student is on. And so as a big believer that, and as I'm sure many of you are, as a big believer in education being the most effective driver of social mobility, of progress, of everything, making sure that people and students and kids remain safe and safe in their education and can go through school feeling like they can just focus on their classes and focus on their schoolwork, has become really, really important to me. And that's how I end up here. And I'm sure a lot of that answer probably tracks to how a lot of people in this call right now ended up in their positions today.
Thanks for sharing that. And thanks for the work that you do.
And thank you too.
So I have another question. I'm curious, so what does it look like for your public justice to protect a child's privacy throughout like a litigation process? Because I feel like there are there are probably a lot of different balls to juggle at the same time, especially if that student is still in a school, like still attending the school in which, this
Mhm.
case is playing out, and, peers might, hear whisperings and things like that. So what does that tend to look like for you all?
So one of the things that we do, this is a great question, by the way. One of the things that we do is often pursue a case under a pseudonym. And so a lot of the cases that we have the name not be the actual child's name, but initials that are either real or fake, Jane Doe, John Doe, that sort of thing, that hopefully protect the child from at least the public scrutiny to a varying extent. But one thing I will say, and this is a word of caution, is that it's true. Schools are gossip centers. Kids talk, kids know everything about each other. And honestly, one of the things that we do tell parents is that going through litigation is a stressful process, not just for you, but also for the child. And so although we can do everything possible to protect the child's privacy and make sure that they are not, being dragged through the mud on the New York Times front page or something like that, there is still a chance that their name gets out, or that something gets leaked, or even if nothing gets leaked, kids will just find out, and that can be a really stressful position for the child to be in. And so we caution the parent that that might be a risk that they're taking on, and we ask the child to make sure that they feel comfortable with that before diving too deep into litigation. That's a really good question, though.
Look like Pam put another question in the chat, and I think this might be a little similar to one of the early questions we had, but she's asking, what is the age groups of the children that are in these litigations?
So that can really, really depend. We work with, with kids who are, range from 4 years old to who are in college right now and have experienced harassment or an assault in college. So, I mean, really the gamut, as soon as you can get into school to the latest you can possibly be in school is the answer.
Are there any other? I have one more question, but I will step back if anybody else who hasn't had a chance would like to ask a question. Okay, I think this is my final question. And I feel like I've probably thought that a couple times, and you keep sparking things, which is great. I'm curious. So what does it look like to, and maybe maybe this is public justice supporting students in this case. Maybe this is a question about how mentors or parents could do this. But what does it look like to support students who, or whoever maybe has experienced discrimination, but they don't end up having a strong enough case to kind of take that forward into a trial or a litigation? What does it look like to still be able to provide support and try to bring some sort of solution or resolution to the situation?
So just to make sure that I understand your question right, so a student or family who, like a lawyer evaluates their case, decides that's not, right for litigation or not right this exact moment, what can be done about their current harassment or discipline or problem they're experiencing?
Exactly.
Is that right?
Yep, exactly.
Oh, okay. So this can be a really long answer because there's a lot that can be done and also very little that can be done, and it really depends on creativity and who you're with and who's helping you and that sort of thing. But I guess to go with a shorter answer, I think there can still be things done to put pressure on a school to affect change, even if litigation is not the exact right route for that student and their family. That can sometimes mean having a lawyer, just show up at school, give, post demand letters, send them letters, like letting them know that this is happening, that this racial harassment is happening, or discrimination is happening, and that they want the school to do something about it. And sometimes the school, once they are on notice from a lawyer, will look to have something happen or have some change happen, even if they think that the legal claim is not strong enough to actually pursue in court. That's sometimes. Other times, a school will be resistant to change and know that that there's no legal argument to be made, or it's a fairly weak one, and are comfortable not making any changes based on that. At that point, I think that there are a couple of things that can still be done. First, you can still reach out to the Department of Education and the Office of Civil Rights, which, they both do, they do federal laws. And so like that would be similar to what we would do. But just knowing that there's a Department of Education investigation happening into a school can often make a school actually respond to change and start implementing change if they are not later flat-footed. And also, let me just pull my notes. And also, sometimes there is a chance that if you simply elevate an issue beyond the school to the board of directors or to a school board in the area, that when they are put on notice of this issue happening in the school, that they put pressure on the school to actually implement change, because they also don't want bad publicity. They also don't want even a chance of litigation, even if they think the litigation claim is not strong, et cetera, et cetera. So even if there's not a direct avenue to, literally getting a judge to order in your favor, there are still ways that parents and students can put pressure on schools, either by, again, working with the school, putting pressure on the school via the board, or putting pressure on a school via, external lawyers and other support systems. And I would say one last thing on the subject. I have had experience with students and parents and families who, again, did not have strong litigation claims, and rather than working with lawyers or anything else, they just decided to organize parents around a certain cause or issue. And so, they know that there are certain students who are bullies at the school who, harass students based on their race or something like that. And they all get together, the parents all get together, and they come to the school and they say that, this has to change. They are willing to pull their kids out if this does not get changed. They are willing to go to the news or the press or something, or do things against the school to make sure that this change is actually effectuated, or there will be consequences for not affecting the change. And sometimes the school does feel the pressure that way, even outside of hiring a lawyer or going above them to the board of supervisors or anything like that.
That's great information. Thank you so much.
Yeah, thank you.
And we're definitely in wrap-up phases, but if there are any other questions, please feel free to, email Shariful after the fact. You can still drop something in the chat. We might have a minute at the end. I do want to, there's a link in the chat right now for a quick follow-up survey. Just let us know how this session was. If you want more sessions, similar to this in the future, or kind of what other topics you would like us to bring to you in 2023, because it's almost 2023, which is wild. I do have a couple of closing, just kind of things that are on the horizon that y'all should know about. And then at the end of this, we will vote for the topic you all want to talk about in January. So stick with us here for just a couple more seconds here. So this is the link that's in the chat right now for you to take the survey and let us know how the session was. There are a couple of really exciting things happening. January is National Mentoring Month, and that means that it's the 13th Annual National Mentoring Summit, which is happening in Washington, D.C. from January 25th to the 27th. And this is a great opportunity to meet with other folks in the mentoring movement. You'll have the opportunity to network, the opportunity to have, there's like 75 workshops and keynotes and all sorts of different learning opportunities happening there. And then there's Capitol Hill Day as well, which is your opportunity to meet with your elected officials, let them know that you want more federal investment in mentoring programs, mentoring initiatives, mentoring research, all of that great stuff. So we encourage you to participate in both of these things, but you can also participate in Capitol Hill Day, even if you are not going to attend the full National Mentoring Summit. If you have any questions about that, feel free to reach out to me. We do also have some toolkits. So if you want to promote National Mentoring Month and kind of leverage this month as a way to, let more folks in your kind of network know that mentoring is important, kind of raise awareness about your mentoring program, potentially reach new funders or new mentors or, any other stakeholders, we do have some toolkits that can easily help you reach out to different audiences, including, media contacts, corporations. There are lots of some great things in these toolkits. So we'll make sure that you have the link to that. We do have some upcoming trainings for you. The collaborative mentoring webinar series happens the third Thursday of every month. So there is one coming up in December. And we also have a new mentor training every second Tuesday of the month. So I think we just had ours yesterday, but you'll be able to register for the upcoming one in January if this is of interest. And then the last thing I'll just kind of plug here is that we do have our no-cost consulting program. So again, these are the lovely faces of our consultant team who do this work on the ground for us. So you would be able to partner with any of these folks on the screen to make enhancements to your mentoring program. If you want to dive deep into evaluation work, you want to work on strategic planning, you want to build out mentor training, all of those things are possibilities through our consulting program. So I'm going to stop sharing and I'm going to launch the poll if I can get that up for you all. So this is to select a topic for January's community coffee hour. So hopefully you all are seeing that right now. We have 3 options up. If you want to talk about marketing, social media, and branding for your program, how to get involved with mentoring and youth advocacy, and then organizational self-care. The 3 very different topics. We'll leave this poll open till we get a critical mass here of folks who have been able to participate. Looks like we're about 58% right now, 64%. Leave it up for just a couple more seconds. Okay, last call. I'm going to go ahead and close this and share the results. And it looks like we have a winner with marketing, social media, and branding. So that is the topic that we will work to bring for you all in January. But in the meantime, thank you all for joining us today. Thanks to Shariful Khan for presenting this great information. Hope everybody enjoys the happy holidays. Great. Take some rest this time of year. And we look forward to seeing you back here in January.
Thanks, everyone. Great meeting you all.
Thank you.
Thank you, everyone.
Thanks. Bye.